Hello, everyone. My name's Amanda Weston, QC. I'm a barrister at Garden Court Chambers, and I would like to welcome you to part 2 of the Garden Court webinar series on the public sector equality duty. We've got 2 fabulous speakers for you this lunchtime. We've got Ollie Persey and Megan Goulding. Ollie Persey is a barrister at Garden Court Chambers, and he's developing a very broad public law practice and also in the Court of Protection, having previously been involved in some very big test cases at the Public Law Project. And Megan Goulding, who you may know already, is a lawyer at the UK human rights organisation Liberty. Megan specialises in privacy and technology and runs Liberty's litigation in this area. She's currently working in particular on state surveillance and police technologies. She acted for a client in the first legal challenge to police use of facial recognition technology, which is a case she's going to be coming to talk to us about shortly. And she's running Liberty's challenges to the bulk surveillance use, both at the European Court of Human Rights and in the UK courts. And then previous to Liberty, Megan worked as a solicitor in private practice. So first of all, I'm going to hand you over to Ollie, who's going to be talking about the PSED, particularly in the context of school exclusions. Take it away, Ollie.
Thank you very much, Amanda. Let me share my slides, and hopefully that's not done too badly. Great. So I'm going to be speaking about the PSED in the context of school exclusions. And I'm really using this context as an example of how the PSED can be used in individual challenges, as opposed to a more systemic challenge like bridges, which Meg will be speaking to later. So by way of a bit of background, I will be speaking exactly what school exclusions are, and then speaking about how the PSED might be a useful tool to address the systemic discrimination as well as individual discrimination in the context of school exclusions. So what's the problem with school exclusions? Well, you might have heard of the school to prison pipeline, and that school exclusions are racist, ableist and classist, and that is because they are, and it is borne out in the statistics. Children with special educational needs or disabilities are more than 5 times more likely to be excluded than their non-SEND peers. Gypsy and traveller children experience hugely disproportionate levels of exclusion, both fixed term and permanent exclusion, and I'll briefly touch on what those terms mean later. And similarly, Black Caribbean children are nearly 3 times more likely to be excluded. If you're on free school meals, you're also more likely to be excluded, regardless of race or disability. So, impact of school exclusions, well, profound. Mostly children end up in a pupil referral unit or a PRU, and PRUs are shown to have a really negative impact on the life chances of children. So if you end up in a PRU, 90% of students there do not achieve 5 satisfactory GCSEs, which is hugely lower than the national average. The impact on mental health, social and emotional well-being more generally, stigma, and from the stigma and isolation of the school exclusion process is profound. Ofsted and the Children's Commissioner, as well as other campaign groups such as Just for Kids Law, the Communities Empowerment Network, have all identified the risk of children being exploited when they enter PRUs and being pulled into the criminal justice system. There's a serious issue in particular with county lines and drug running for children. Evidence shows that children are quite often have drugs planted on them. They incur the wrath of zero tolerance school exclusion policy of no drugs. They end up in a PRU where they're much more vulnerable to being targeted. So the issue of school exclusions is one where where there is structural discrimination and significant disadvantage visited upon young people who are a particularly vulnerable cohort. So just to give you a little bit of the terminology that's used in school exclusions, and then I'll talk through how the PSED can be folded in as a tool to challenge the discrimination both at an individual level, but also to address the structural discrimination that exists in this environment. So a permanent exclusion, or a PEX, is what used to be called an expulsion, and I think the terminology is changing back to expulsion shortly. And essentially, they're removed from the school role and they need to find another place to go, which is most likely going to be a pupil referral unit because other schools will decline to take them. A fixed term exclusion is a shorter period of time. Generally, it isn't challengeable through the review process unless it's 15 days or involves discrimination. Then there are two forms of exclusion which some people do not term as exclusion, but I think is useful and can be challengeable, which is internal exclusion. So useful terms, not useful practices, just to be clear. And internal, sorry, so Amanda's notes, and I thought it might be for me, but no, it's for everyone to post their Q&A in the box, and please do so. So an internal exclusion, or what might be deemed a sort of putting in an isolation room or removing from the rest of the school environment, is a type of exclusion. And then an informal exclusion is basically sending a child away from school but not following the processes. And this is always unlawful. So we don't generally need to get into issues of the PSED in that context. So this slide basically sets out the mechanics of when such exclusions can be reviewed through the school exclusions process. And any, as I mentioned, any that where discrimination is alleged can be challenged. PEXs, fixed term exclusions of 15 days, and then 5 to 15 days, it's optional for a parent to pursue an appeal through the exclusion process. It's worth noting, and I think this is a PSED issue in itself, that the right of appeal is only exercisable by parents. They're the relevant person that has the appeal rights under the regulations. Query whether that is lawful, given the potential conflict of interest, particularly where there's a corporate parent, such as a local authority, and the importance of promoting the child's voice in proceedings as set out in the UNCRC. So what is a school exclusions process? And I will get onto the PSED shortly, but this is important foundation so you understand what I'm actually saying when I say GBH. So a governor's body's hearing is the first stage, and it's essentially a review by the school's governing body of the decision by a head teacher to make an exclusion. It has powers to reinstate if necessary. Then there's an IRP, or independent review panel, and this is supposedly a quasi-judicial review process, and it's an appeal panel assembled generally by a local authority of purportedly independent people who will review the decision of the governors to whether to uphold an exclusion. It doesn't have powers of reinstatement. It can direct reconsideration by the GBH, the governor's body hearings, and it can provide some sort of force behind that by a threat of penalty to the GBH, but it doesn't have any powers to mandate a child to return to the school. Then there's the first tier tribunal, which I'll touch on briefly, which is the Special Educational Needs and Disability Tribunal, and that hears claims in relation to disability discrimination under the Equality Act. And then there's the county court, which might be a forum for a race discrimination claim in the same way that any other form of race discrimination claim might be brought. And then there's the High Court for judicial review. And judicial review might be appropriate when you've run out of all of the remedies and you're not getting reinstatement through the process. So what the PSED in the school exclusion process. So I really want to think about the PSED and how it applies in individual cases, and how the school exclusion process is an interesting example of where we can be using PSED arguments more to address both the structural discrimination and individual discrimination. Now, it's important to remember that the PSED is not just about formulation of policy, but application of policy. And a useful case that considers this, admittedly in the predecessor legislation to the Equality Act, is a case called Pieretti, where it's made quite plain that actually not just the policy, but application of the policy in a specific decision, e.g. homelessness, but also, I think, the decision to exclude for breach of a behavioural policy. So just in the way that a housing policy might be challengeable, and a decision about whether someone is homeless might be challengeable specifically, a behavioural policy in a school is challengeable, but the application of that behavioural policy on an individual level also must be compliant with the PSED. So it's important to remember that it's a non-delegable duty. And I know all of these points that I put on my slide were covered in the previous session, but I just wanted to remind people of them, but also focus on how they apply in this context. So non-delegable duty is quite important here, because the decision to exclude is also non-delegable. It has to be, with a few exceptions depending on the type of school, which I'm not going to go into. If it's a state school, and we're only talking about state schools here, not private schools, it is a non-delegable duty on the head teacher. So the PSED, similarly, should be discharged by the head teacher, or at least he has to be aware of it, has to have some involvement in it. There can be some form of delegation, in the same way that the Home Secretary doesn't personally complete an equality impact assessment, but it will generally go via ministerial submission up to the Home Secretary for sign-off, and they must turn their minds to the questions themselves. Now, when should the PSED be exercised? Well, it's meant to be before and at a decision, and then it's a continuing duty thereafter. But by being a continuing duty, that is no defence for having failed to undertake that due regard at the material time, particularly when it's a specific decision like this. The case law is clear on cases such as bracking, etc., which Miranda went through last time, that the PSED cannot be run by a rearguard action. So the classic example of this is, look, we don't think you complied with the PSED, and then they go and do an equality impact assessment after you've raised it. That would not be sufficient. So, for example, if you got into a GBH and the school said, look, oh, we've now thought about the equalities impact and we wouldn't have done anything differently, that wouldn't be good enough, because to show compliance with the PSED, it must be entered into with an open mind, which is my next point, with substance and rigour. If you're doing it, if you're attempting retrofitting, it's both a rearguard action and not really with the open mind that is required by the PSED. Now, we know from the previous presentations a few weeks ago that this the PSED incorporates what's called a Thames-side duty of inquiry. And that is a duty for the decision maker to equip themselves with all the relevant information and ask themselves the relevant questions for them to come to a rational decision. Now, the Thames-side duty of inquiry is context specific. And we know that from a line of case law, from refugee action to HOTAC in the Supreme Court, which specifically considered the PSED. Now, how intensive should the PSED be in this context? Now, I would make the argument that it should be very intensive. So, looking back at the statistics that I went through at the beginning of my presentation, the racial disparity, the ableism disparity, particularly where a student has combined protected characteristics, surely that should be an intensive scrutiny, because the purpose of the PSED is meant to be about embedding considerations of structural inequality in decision making to address structural inequality. And the school exclusions process, in my view, is a paradigm example of that. The impacts of the exclusions, what I went through previously about the school to prison pipeline, the impact on academic attainment, the disruption caused to a child in a very important period of their development, all, I think, point in favour of a more intensive duty of inquiry in this context. What can you look at the structural discrimination at both a school and a national level? I think yes. Even if a school doesn't have a particularly bad racial disparity statistics, why it exists in an environment that is structurally racist, and those two cannot be separated. However, I think there is an argument about a less intensive review because it is only one individual. So the case law such as refugee action concerned 20,000 individuals. The level of scrutiny for a policy that affects that many people, and in that case, vulnerable migrants, is, I think, a factor for greater scrutiny where you have a wide-ranging impact. But for the aforementioned reasons, I don't think, I think if we're weighing up the balance about how much scrutiny should be provided, there are significant reasons why there should be something close to an equality impact assessment, in my view, depending on the context of the case, depending on the protected characteristics, depending on the particular disadvantage of the school, of the student, and the rates in the school. I think there's an argument that it should be an equality impact assessment that is discharged, is completed by a head teacher before they exclude. And we should be running those arguments in school exclusion hearings, which generally they're not being run at the moment. So I just briefly, and I'm conscious of the time, wanted to talk about the PSED and the SEND Tribunal. Now, the SEND Tribunal only has jurisdiction to consider Chapter 1, Part 6 of the Equality Act. So the standard heads of causes of actions, for example, direct discrimination, indirect discrimination, harassment. However, there is a link between the PSED and discharge of the duties, those duties under the Equality Act. And we've seen that, and I think Steph mentioned it in the previous session actually, that there's a case called Cole against Secretary of State for Justice. And as it was applied in Steph's case of Hussein against the Secretary of State for the Home Department, failure to discharge the equality, public sector equality duty is evidence of a failure to justify indirect discrimination. So while you formally cannot plead PSED breach in the SEND Tribunal, you should, I think, be putting this responsible body, the school, to prove that they have discharged their PSED. And if they haven't done so, and your indirect discrimination claim relates to the same issue, I think there is an argument that they'll really struggle both on indirect discrimination and discrimination arising as a consequence of disability, which both have a proportionality justification limb to them. I think they would really struggle to make out justification if there's a complete absence of due regard, even though the PSED isn't in scope of the tribunal's jurisdiction. So that brings me on to my final slide, which is the issue of the School Inclusion Project, which is quite an exciting slide for us to talk about, which is a new initiative coordinated by Garden Court in partnership with the Law Centres Network, the Communities Empowerment Network, and Just for Kids Law, in which we will be attempting to address some of the systemic discrimination in the school exclusions process. It's going to be launching at an event on the 20th of July, and more information will be sent about that shortly. But there are three core aims of the School Inclusion Project. First, to develop a referral pathway for representation in school exclusion hearings and related proceedings, because we need more lawyers on the ground making those PSED arguments, which are quite technical. And because it's out of scope of legal aid, those arguments aren't being made, and structural discrimination isn't being challenged in the way that it should be. To share knowledge and best practice, and then to identify and address systemic unfairness in schools. And the way that this will be run is through the forum of a Google group with quarterly meetings, and it's somewhat inspired by the Housing and Immigration group, which many people on this webinar will also be members of. So please keep your eyes on your emails for more information about that. And that is the end of my presentations, and I look forward to answering any questions that you might have about PSED in individual challenges or school exclusions more generally. Thank you very much.
Thank you very much, Ollie. That's amazing. Very informative as always. Super excited about the schools inclusion project. So at this point, I'm going to hand over to Megan Goulding of Liberty, who's going to talk about her recent case of Bridges. So take it away, Megan.
Thanks, Amanda. Hi, everyone. As Amanda said, I'm Meg Goulding. I'm one of the lawyers at Liberty, the UK human rights campaigning organisation. I was also solicitor for Ed Bridges in his recent judicial review, challenging South Wales Police's use of live facial recognition. And as Amanda said, that's the case that I'm going to speak for the next few minutes about, specifically focusing on the Court of Appeal's findings on the PSED. Next slide, please. Thank you. So for those that don't know, here's a bit of background to the case itself. South Wales Police began trialling live facial recognition in May 2017. They were the first police force to use the technology, funded, actually, I'll correct myself, it was used once by Leicestershire Police at Download Music Festival. But after that, it was South Wales Police who rolled it out for the first time. And they were funded by the Home Office to do so. They've deployed around 70 times now, although to our knowledge, not since the Court of Appeal judgment in Bridges. They started using the technology at large-scale public events, so sports matches, music concerts, that kind of thing. But more worryingly, quite soon after, began using it as part of everyday policing, parking vans with the cameras on top in streets in Cardiff in the hope of capturing images of people walking past. For those that don't know, although it's quite familiar by now, live facial recognition works by taking or extracting from CCTV images of people's faces as they walk past the CCTV camera. It then uses their facial biometrics to compare them to a watch list. And if police identify someone as being on their watch list, they may stop them, question them, search them, or potentially arrest them. And there are no clear rules on who can be added to a watch list. That's one of the more worrying aspects of this technology. And indeed, that was part of Ed's judicial review. So Ed himself was scanned twice. First time was December 2017, when he popped out to buy a sandwich at lunchtime in Cardiff from work. The second time was at a peaceful anti-arms fair protest in March 2018, again in Cardiff. So Ed brought a judicial review against South Wales Police on the basis that their use of facial recognition was firstly incompatible with the right to privacy under Article 8 of the European Convention on Human Rights. Secondly, that it breached data protection legislation. And thirdly, and most importantly for our purposes, that it breached the PSED. So in terms of the PSED, what Ed claimed was that South Wales Police had never had due regard to the need to eliminate discrimination on the grounds of race or sex which might arise in their use of live facial recognition. For those that don't know, studies show that there are much higher rates of misidentification of people of colour and women by facial recognition. And of course, that has the knock-on effect of many more people within those categories being stopped by the police, searched, questioned, arrested. It's worth saying that there are now studies showing higher rates of misidentification for other groups as well, including trans people, for example, and disabled people. But the focus in Bridges was on racial and gender bias. And the reason that there are these higher rates of misidentification is that there simply aren't sufficiently high numbers of facial images of people of colour and women contained in the data set of faces that are used to train the technologies. The technologies are trained to recognise white male faces. So even at the start of this judicial review, this was a relatively well-known fact that there was this potential for inbuilt bias in facial recognition systems. And yet, it quickly became clear in our case that South Wales Police did not have any access to information from the private manufacturer of its facial recognition technology about the demographic composition of their training data set. And South Wales Police had also not carried out sufficient testing themselves of this bias. They had done an equality impact assessment, but it was possibly one of the worst ones I've ever seen. In answer to the question, is there potential here for racial discrimination or gender-based discrimination, they had simply answered, no, we're not looking for people based on their race or based on their gender, which showed a completely wrong understanding of this potential for inbuilt bias in the technology. So in September 2019, the Divisional Court gave its judgment in Ed's case and dismissed his claim on all grounds. On the PSED, they found that South Wales Police had not breached the duty, since when the trial of facial recognition commenced, the police had not recognised, nor should they have recognised, that their technology might discriminate. Thankfully, in August 2020, the Court of Appeal took a different track and allowed Ed's appeal on all grounds, including that the Divisional Court was wrong to hold that South Wales Police had complied with the PSED. And rather surprisingly, there was no appeal of that judgment by the police, so the judgment stands. And we'll move on now to what the judgment says. Next slide, please. Thank you. So the ultimate conclusion of the Court of Appeal on the PSED is there in the red text box on the right-hand side. South Wales Police have never sought to satisfy themselves that the software programme in this case does not have an unacceptable bias on grounds of race or sex. But there are three, what I think are quite interesting points from the Court of Appeal's PSED reasoning that I want to just draw out with you today. So the first of these points is that the court found that public authorities cannot rely on a lack of evidence or information to discharge their PSED. And this point was made in two ways by the court. The first was that the court found that the Divisional Court was wrong to be persuaded by the fact that when the trial started, there was no evidence before South Wales Police that their tech might have a racial or gender bias. In the Court of Appeal's words, this was to put the cart before the horse. The Court of Appeal explained that the purpose of the positive duty, the positive PSED, as opposed to the negative obligations in the Equality Act not to discriminate, the purpose of the PSED is to ensure that a public authority does not inadvertently overlook information it should have taken into account. So what the PSED requires is public authorities to take reasonable steps to make inquiries and ascertain what may not yet be known to them. So what South Wales Police should have done is they should have gathered information on whether their tech discriminated, and should not have relied on the fact that they didn't know that it did discriminate. The second way that this first point was made by the court was in finding that South Wales Police couldn't rely on the fact that the manufacturer of their technology wouldn't reveal the demographic composition of their training data set. The Court of Appeal showed that it was understanding as to why manufacturers might not want to release that kind of information for commercial confidentiality reasons. Nevertheless, they found that South Wales Police should have sought to satisfy themselves that the tech was not biased. And what they couldn't do, the police, was rely on broad reassurances from the manufacturer about the data set. So we had a witness statement before the court where a representative of the company who manufactured the technology was explaining, don't worry, there are broadly similar numbers of men and women in our training data set, and we try to include images of people of colour, so there's no cause for concern. Relying on those kind of broad statements wasn't enough. And in any event, that witness statement had, of course, been given after the event and during the litigation. So I suppose what the court was confirming here is something that we already know, but in emphatic terms, that the PSED is non-delegable, including, importantly, that it can't be delegated to a private company supplying technology to a public authority. Next slide, please. Thanks. So the second key point from the court's reasoning is that PSED requirements for trials are no less stringent. So what had happened was, before the divisional court, South Wales Police had argued that it would simply continue to review events during the course of the trial against the PSED criteria in section 149 of the Equality Act. And the divisional court had accepted that as the correct approach in the context of a trial. Thankfully, the Court of Appeal rejected categorically that approach. They stated in no uncertain terms that the PSED does not differ whether something is a trial process or not. And in fact, they went further to say, if anything, during a trial, it's more important that a public authority gathers relevant information in order to conform to the PSED and avoid discrimination. The third key point that the court made was that PSED requires proper process. Now, I think this is interesting because rightly, the PSED is sometimes thought to be quite limited in being a duty that's just about process. But here we see the police trying to rely on a substantive outcome, or what they said was a substantive outcome, to justify a failure of process. And the court rejects that and holds them to a higher standard of proper process. So what happened was, in reaching its decision, the divisional court had emphasised the significance of what it termed a human fail-safe, i.e., two police officers have to review any potential matches alerted by the facial recognition system before any action is taken by the police. The Court of Appeal held that the human fail-safe was insufficient to discharge the PSED. It firstly noted that humans often make mistakes in the context of identification, and indeed that's been my experience watching the police respond to alerts on the system that clearly aren't the same people. But more importantly, perhaps, the Court of Appeal held that the human fail-safe is simply not material to the question of the PSED as a matter of principle. And that's because the PSED, as we've said, is a duty of process, not substance. And in this case, South Wales Police had not as we've seen, carried out the proper process. They hadn't investigated the inbuilt bias in the technology. Next slide, please. So what conclusions can we draw from the Court of Appeal's findings on the PSED and bridges? A very basic but important conclusion is appeal your judgments where you lose on the PSED, not just bridges, but there are many other cases showing that the PSED arguments may not have been properly understood or decided upon first time round, but on appeal, either in the Court of Appeal or Supreme Court, have had much greater success. I think it's also notable that the PSED part of the Court of Appeal's judgment began with a really robust defence of the historical and the continuing importance of the PSED, especially, the judges noted, in the context of the enduring public concern about relationships between the police and communities of colour. Out of all the various bits of the court's PSED findings, I think what's particularly useful is their observation that even when private manufacturers refuse to release information, that doesn't let public authorities off the hook. They must investigate bias. And I think this finding is going to have a knock-on effect, I hope it will, on other public use of privately manufactured technology. And as public authorities jump at the chance, unfortunately, to rely on technology to carry out their functions, this will apply in even more cases. So where there are then questions about whether a tech was designed or trained in a way that might give rise to bias, the public authorities can't rely on a lack of information. They can't rely on broad reassurances from a manufacturer. They have to do their own testing. Hopefully, in the longer term, this will result in manufacturers providing more information on the way they train their technologies or design their technologies. Or alternatively, and probably more likely, it will result in further testing by public authorities. But either way, hopefully discrimination will be better exposed and mitigated, if it can be mitigated, before technology is rolled out. I think it's also significant that the Court of Appeal rejected South Wales Police's claims of having complied with the PSED. So we've already talked about how they dismissed the police's reliance on a human fail-safe. They also dismissed the police's own statistical analysis that they had done of bias. They said that it was off point and it was non-expert. And this is significant, I think, because it shows, I apologise if you can hear drilling in the background. There is drilling going on in my neighbour's front garden, but I hope you can still hear me. It shows the court's not just accepting claims of compliance out of hand, but instead applying a careful scrutiny. In turn, I think this will bolster the PSED. And finally, just to say, it's a huge relief, of course, that the court found that PSED requirements apply during trials. This is particularly important, I think, as we see an increased tendency of public authorities to term what is in fact actual deployment of new technologies as trials. It's notable in this case that South Wales Police had set no end date for their trial. It had been going on for years, and there was seemingly no objective criteria by which they were assessing the trial. It was, in all senses, real deployment. Next slide, please. Just some final thoughts for practitioners off the back of bridges. Expert evidence was incredibly useful, possibly critical for us in getting the court to reach its PSED conclusions. And I think that's something for others to consider deploying in future PSED claims. So we put in 2 expert reports from an expert in biometric technologies. He explained to the court how facial recognition in general worked, but critically also how this bias could be inbuilt into the system. And he also, in his second report, which responded to the police's witness statement about their own statistical analysis, our expert explained to the court why that analysis was off point, why it was looking at the wrong statistics and drawing the wrong conclusions. And the court did cite those two expert reports several times in their PSED judgment. There are limits, of course, still to the PSED. We all know that, being as it is a matter of process. It's a waiting game still to see how the police now try and comply with the PSED in relation to further deployments of live facial recognition. We're, of course, fearful that they may still tick enough boxes to satisfy a court, but facial recognition may still have a discriminatory impact. It might be important in the future for those of us thinking of bringing facial recognition litigation to think about bringing direct or indirect discrimination claims, in addition to claims of breach of PSED. For those of us doing wider campaigning and advocacy work around this issue, we may want to think about trying to have introduced procurement obligations. So public authorities have to receive certain information from manufacturers about training data sets and so on. Or alternatively, or in addition, we might want to try and get a requirement in place for public authorities to publish bias testing to allow for independent verification, off the back of having seen how poorly South Wales Police did their own testing, which only became public through the litigation. Finally, just to flag for those interested, though I appreciate I'm getting pretty niche on the topic of facial recognition, draft guidance on the use by police forces of facial recognition has now been published by the College of Policing. It seems in response to Bridges, because it focuses on deficiencies identified by the Court of Appeal. It does mention the potential bias in the technology. So in that sense, it's more honest than South Wales Police ever were. And it mentions the need to comply with the PSED. But worryingly, there is no practical guidance in that guidance for police to know how to conduct their testing, nor a recommendation for third-party testing or verification. There's also no acknowledgement that the PSED applies in the facial recognition context beyond inbuilt bias, which is, of course, what we've discussed today because it's the focus of Bridges. But the PSED also applies to the decision to put of what images to put on a watch list, of the decision of where to deploy the technologies, whether to deploy in areas with high Black populations, and so on. So we have to just wait to see what form the published guidance takes. If it looks like what we currently have in draft, that may lessen the practical impact of Bridges if police have free rein to determine and run their own tests of bias for PSED compliance. But let's wait and see. That's all I have. Thanks, Amanda.
That's a fascinating insight into the granular experience of running complex litigation on the PSED like that. Meg, thank you very much. I'm just checking the Q&A box and I'm not seeing any questions in there, but there were two questions which came up earlier. The first one's for you, Meg. And that is, so you've got your judgment in your PSED challenge and you're waiting for systemic change, but the stats aren't telling you anything has changed. So what are your options?
Thanks, Amanda. So, well, at the moment, it seems that the police aren't deploying live facial recognition at all, but we would be naive to think they don't have plans to do it soon. So if they were to deploy facial recognition in a way that we think still doesn't comply with the PSED, they haven't done the rigorous testing that's required, there's a few options available to us. Of course, the first is to bring a new case challenging continued non-compliance with the PSED. Another option would be to ask the Equality and Human Rights Commission, the EHRC, to use their enforcement powers around the PSED. So those powers are set out in the Equality Act 2006, and they can do various things. They can carry out an assessment themselves of whether the police have complied with the PSED. If they decide they haven't, they can issue a notice requiring compliance. If the police still don't comply, then the court can enforce compliance, and there are fines, or in the end it becomes a criminal offence along the way not to then comply. And there are other powers also set out in the Act, powers that the HRC have to seek injunctions, carry out further investigations, or seek agreements with the police that they do comply. So that would be one option. You'd have to convince the EHRC, of course, that this falls within their priority areas. And also, I think they've got a policy which sets out factors they'll consider when deciding whether to take this kind of action, like how big is the problem? Does it affect the whole of the UK? What are other stakeholders saying? So you'd have to make a case to them that this was an important issue that met their thresholds. One other option that's popping into my mind now would be, a campaigning organisation like Liberty might think about putting out template letter before claim on their website, say that people can use if they believe themselves to have been scanned, and they can start claims alleging breach of the PSED. One consequence of a high number of those types of claims would, of course, be that the solicitors for the police force would be overloaded, and hopefully that would be impetus enough for them to stop their unlawful action, because the lawyers don't want to fight thousands of cases. Yeah, those are options available.
That's great, Meg. Thanks very much. I also had a question for Ollie. Now, Ollie, you were talking before about the problems of systemic challenges not filtering their way through because the important arguments aren't being run at the outset. Do you know if the school's inclusion project has got any plans to tool up parents, as well as providing pro bono representation when possible? You're muted, Ollie.
Just after a presentation on tech. Oh dear. Yeah, I think the plan is to empower everybody to use these tools as much as possible. If we can democratize the Equality Act so that people can use it, a bit like the PAP project model that Meg was talking about just now, if we can get people arguing putting these arguments in every possible forum, with or without representation, with legal representation or a more informal form of representation, there are various sort of bar student voluntary schemes doing school exclusion work, then absolutely, yeah, all for training up everybody. And I know Southwark Law Centre, where I'm a trustee, is doing some work training up parents groups on Equality Act and race discrimination in schools. So I think that is the way forward. Just on the question that you asked Meg, I wonder if this started being widely used, whether the EHRC could put out guidance on procurement, but also use of facial recognition more generally. They've put out guidance in relation to PSED in a schools context, and I'd argue that it's deficient guidance because its section on exclusions is pretty empty. But yeah, that might be another tool as well. And now you're on mute, Amanda.
Thanks very much. We've got a couple of questions in the chat box, and I don't know which of you wants to answer this one, because it's very interesting. So how good a tool is the PSED to deal with issues of intersectional discrimination? Oh, you've gone very quiet, both of you.
Well, the Equality Act generally is pretty bad on intersectionality. It's different heads of claim, different protected characteristics. But the PSED, as I mentioned, incorporates a Thameside duty of inquiry, which is context sensitive. And I think there's an argument that the vulnerability of a particular group, which can be, which links into multiple disadvantage, which could be a combination of racial oppression, disability-related oppression, sex-related oppression, all of those factors, say you had a particularly vulnerable group being affected by policy change, such as cuts to women's refuge, particularly if it was in an area that supported women of colour, a more intensive duty of inquiry would be required. And in that way, you could fold in arguments about intersectionality, potentially.
Yeah, I see here there's, thanks very much. Meg, did you want to add anything?
All I was going to say, and I'm not sure how helpful it is generally because it's very specific to the Bridges case, but part of our expert evidence was focusing on the fact if you're a woman of colour, then you're the most likely to have misidentification made, a wrongful match, over and above men of colour and women who are white, and that seemed to be kind of understood and accepted by the court, though it didn't in the end become really material to our PSED challenge. And the only last kind of small point to add is that the equality impact assessments that I've seen in the past are not good on intersectionality. They ask the questions of, is there race, potential for race discrimination through this measure? Yes, no. Gender discrimination, yes, no, and so on. I think it's kind of on us as lawyers to point to the deficiencies there before the courts as well.
And always, as always, you're in a there's a situation of circularity, isn't it? If they don't ask the questions, then there isn't the evidence, and you're always going to be contingent on finding other stakeholders or who can provide that evidence for you. Thanks very much. So there's a question here, says, maybe basic, does PSED apply to Student Finance England? That's an interesting question. Firstly, it applies to any public authority. So in principle, if Student Finance England is carrying out a public function, then yes. But interesting, and it's important to remember this, it's not Student Finance England that drafts the regulations for student funding. It's the minister with responsibility for that is the Secretary of State for Education and Employment, who of course is bound by the PSED also. It's important to remember that. I hope that's enough of an answer. We found somebody here who's posted some interesting information relevant to discriminatory algorithms in the criminal justice system. That's there for everyone to see. And then the last question here from Jensen Lamb is this. Have you found that the PSED has generally been a more effective route of challenge in non-housing areas than in housing? In terms of possession and homelessness, PSED arguments seem to have been having a bit of a kicking over the last few years. Would either of you like to comment on that?
I'd struggle to comment as I don't do any housing work. So have had more success outside of the housing context by virtue of never having done a housing related PSED case. Yeah, I've heard bad things about PSED in a housing context from colleagues that do that work, but
yeah,
can't say.
Yeah, I mean, these things go in waves, don't they? And obviously the more heavily resource-based challenges and the resource allocation-based challenges are always going to be dogged by the judicial resistance to the idea of equality law having something to say about that. Well, I see we're only 4 minutes off 2 o'clock now, and I'm sure you've got things to get back to. Unless either of the panelists had anything they wanted to add at this point, can I just say thank you very much indeed to Meg Goulding and to Ollie Persey for very informative presentations. I hope they were useful. And as always, this webinar will be available by way of a recording, which you can access when David de Menezes, our marketing person, sends it round. And if you do have any questions arising from today that you didn't get to ask during the webinar, then forward them to us, and I'm sure we'll do our best to answer them. Thank you very much, everybody, for attending, and goodbye.